Hey everyone, today we are going to talk about the first part of the law of negligence, which is duty of care. The law of negligence has evolved since the seminal case of Donahue and Stevenson. It was a House of Lords decision where a woman, she drank a can of ginger beer and there was a dead snail in it. So she was shocked and she fell ill and she sued the manufacturer. The court held that the manufacturer of the drink, owed a duty of care to her because it was reasonably foreseeable that a breach of the duty of care would lead to harm to consumers consuming the drink. There was also a sufficiently proximate relationship between consumers and manufacturers. There have been many tests developed over the years on whether a defendant owes the plaintiff a duty of care. In other words, a duty to look out for the plaintiff and not to cause him loss or damage. In Singapore, the courts have used many old tests, including the neighbour principle, the ANDS 2-stage test, the Caparo 3-stage test. In 2007, the Singapore Court of Appeal finally settled on the spandex test in the case of Spandex Engineering and DSTA. The test the test is a 2-stage test of the kind proposed by Justice Pang in Sunny Metal. Essentially, the 2-stage test comprises first a proximity test and then policy considerations. These should be used to determine whether there is a duty of care in all situations. I'll go on to talk about proximity. The first stage of the test to determine whether the duty of care exists between the claimant is whether there is proximity, which means closeness between the claimant and the defendant. So like in the Donahue and Stevenson case, the court held that the consumer of the drink and the manufacturer of the drink, there was sufficient closeness to establish a duty of care. Proximity could include physical proximity in the sense of space and time between a person or property of the plaintiff and the person or property of the defendant. There's also circumstantial proximity, such as the overriding relationship of employer and employee, or of a professional man, for example, lawyers, doctors, and accountants. There's also causal proximity in the sense of closeness or directness of the causal connection between the defendant's act and the loss sustained by the plaintiff. Other matters that the court will consider relating to proximity is whether there was a voluntary assumption of responsibility by the defendant to take care to avoid causing loss to the plaintiff, and reliance by the plaintiff on the defendant to take such care in circumstances where the defendant knew or ought to have known of that reliance. Now I'm going to talk about policy reasons. The second stage of the test, the spandex test, requires the court to take into account policy considerations to determine whether or not there is a prima facie duty that has been established, should be negated, which means cancel or ignore. An example of relevant policy consideration is the existence of a contractual matrix which precisely defines the rights and liabilities of the parties as well as their relative bargaining positions. So, if the defendant, the person getting sued for negligence, his obligations had already been clearly and specifically set out in the contract, and his negligent act fell outside the scope of liability of the contract, then public policy considerations might apply to negate the defendant having a duty of care to the plaintiff, who is the other party of the contract. Another policy consideration against imposing a duty of care would be on public authorities. For example, like the police or the civil defense force or medical staff in ambulances, because the public authority might then have to divert limited time and resources away from carrying out its operations to defend against lawsuits for negligence. For example, if you impose a duty of care on policemen or people working in the civil defense force or hospital or ambulance staff, then if they are found to owe a duty of care to all these people, then they'll be flooded with negligence lawsuits if anything bad happens while carrying out their duties. So for policy considerations, the courts will not want to impose a duty of care on such public authorities. So thanks for watching the first part of the video on negligence. Do stay tuned for the other videos on the remaining elements of the tort of negligence.